I've always believed that if you're going to outplay someone, let them believe they're winning until the final move, and no one gave me a better opportunity to prove that than Karen Maddox, self-appointed queen of our HOA, developer wannabe, and the woman arrogant enough to break ground on a 100-unit apartment complex without realizing she just handed me the greatest real estate windfall of my life. My family had owned the 10-acre parcel on the edge of the neighborhood for almost 70 years, passed down from my grandfather, then my father, then me, and while I never built on it, I kept it pristine, zoned rural, technically outside HOA jurisdiction, with rolling grass, a small creek, and a deed so clean you could frame it. It bordered the neighborhood on one side, but legally it was my own little country. I kept the fencing low, posted signs where required, and left the back gate open most days for the local wildlife to come and go. I had no interest in selling, despite the occasional offers from realtors and developers who circled like vultures. Karen was one of them, though she never came to me directly at first. She liked to use proxies. About 3 years ago, she started showing up at HOA meetings with phrases like community expansion, increasing revenue, and affordable luxury apartments. It didn't take a genius to figure out she had development ambitions, but most of the neighborhood just humored her, assuming it was another of her power fantasy initiatives that would burn out in a month. But I kept my ears open. I'd seen the way she operated, half rules, half intimidation. She'd find people for mailboxes being too colorful or planters being unapproved shapes, all while forging connections with shady developers who were desperate enough to gamble on her half-baked ideas. And then, out of nowhere, trucks started arriving. Not just landscaping crews or surveyors, bulldozers. It was a weekday morning when I got the call from my retired neighbor Rick. "Hey, are you building something? 'Cause there's a crane tearing up the edge of your property." My blood went cold. I drove down immediately and saw the fence gone, half the topsoil scraped off, and a portable construction office parked like it belonged there. And standing in the middle of it all, clipboard in hand, hard hat over her freshly highlighted hair, was Karen. I didn't even get out of my truck. I sat there watching her, stunned by the audacity. She saw me, waved like she was greeting an old friend, and walked over with a smug little smile. "You're gonna love this," she said, tapping her clipboard. "This is going to double property values over here." I stared at her. "You're on my land, Karen." She blinked, confused for half a second, then forced a smile. "That back section? That's HOA common use zone now. Annexed via overlay zoning. You would have gotten the notice if you checked your email." My jaw clenched. There is no such thing as HOA annexation of private land. "Oh, you're one of those old-school D guys," she said, rolling her eyes. "It's more nuanced than that. The committee voted to rezone this into multifamily utility space. It's in the bylaws." "My deed overrides your bylaws," I said calmly. "You're trespassing." She patted my door like I was a confused puppy. "It's already in motion. You'll see." And that's when I made a choice. Not to yell, not to file a complaint, not to call the sheriff and make a scene. No. I went home, poured myself a glass of bourbon, opened my safe, and pulled out the original deed, complete with handwritten notes from my grandfather, a notarized boundary map, and the mineral rights clause everyone seemed to forget about. Then I sat down at my computer and opened a blank folder titled Operation Empire. Because if Karen wanted to build 100 apartments on land she didn't own, I wasn't going to stop her. I was going to let her finish and then take everything. Over the next few months, I watched her construction project unfold like a slow-motion train wreck with gold-plated railings. The HOA somehow approved every step. She called in favors, pulled shady permits from city contact, even started giving VIP tours to prospective tenants while half the foundations were still mud pits. I stayed silent. I smiled. I walked the property lines twice a week, photographing everything, logging timestamps, collecting a mountain of documentation that would eventually become the sword she fell on. She never asked for permission. Not once. She never paid for access. Never offered a lease. Never filed an easement. She just assumed that her title, HOA president, was enough to supersede state zoning laws, private property boundaries, and basic decency. It wasn't. But I wanted more than to shut her down. I wanted the entire development. And for that, I had to wait until the last concrete slab was poured, the last tenant agreement signed, and the last dollar of her own money sunk into the bones of something built on sand. So I waited and watched. Watched her throw community events at the construction site, complete with champagne tints and fake ribbon cuttings. Watched her boast to the board about her legacy. Watched her use HOA funds to cover marketing expenses, office furniture, landscaping contracts. It was all legal, technically, because she had board majority. But none of it accounted for the fact that the entire structure was on my land. And in real estate, the dirt is everything. She launched her leasing website 2 months before completion, promising move-in ready units by spring. She even named the complex the Villas at Evergreen Commons, complete with a fake address that just piggybacked on a neighboring parcel. I kept track of every lease she signed, every promotional promise, every dollar invested. And when the last unit was finished, when the celebratory email went out to the HOA titled Dream Realized, with a photo of her standing in front of the first finished building, I smiled, walked into my study, and opened the manila folder marked Final Strike. Because now the trap was set. And she walked right into it with both heels clicking like a queen on parade. By the time Karen cut the red ribbon in front of building with her oversized gold scissors and her even bigger ego, I had already filed the first 312 pages of legal documentation with the County Land Records Office. And the thing is, she didn't even know it because I didn't make noise. I made progress. The trap wasn't in the moment she broke ground. It was in every week afterward, every document she filed without verifying who actually owned the soil under her so-called masterpiece. I had consulted 3 different property lawyers, not because I needed their validation. I had taught most of what they knew in lectures at judicial review conferences, but because I needed to make sure every was dotted and every comma couldn't be used against me in court. I wanted no ambiguity, no wiggle room, no possible spin she could twist into another flyer or manipulated HOA vote. I had copies of the deed, the mineral rights, the easement records. Hell, I even had drone footage showing the exact placement of every foundation slab crossing onto my land. See, what Karen failed to understand, what so many like her always fail to understand, is that power isn't about noise. It's about leverage. And she gave me all the leverage I needed when she poured the first bucket of concrete without ever filing a single permit with my name on it. The moment she did that, she made a classic fatal mistake. She improved someone else's land. And legally, that gave me options. I could sue for damages. I could demand removal. I could force her into a forced settlement. But none of those appealed to me, not when I could go for the kill shot. Under adverse possession laws and enrichment doctrine, I had a legal pathway to claim ownership of the structures, every square foot of her 100-unit fantasy, because they were permanently affixed to property I owned. That meant everything she'd built could become mine, if I played my hand right. And oh, did I. The first thing I did was pull a certified boundary survey, updated to the inch, stamped and sealed by a licensed state surveyor. I had it filed publicly, attached to my deed, and mailed a copy to Karen's personal residence with a little sticky note. "You're building dreams on my dirt." She didn't respond. Not in writing, anyway. But 3 days later, I saw her pacing in front of Building C with a man in khakis and a rolled-up blueprint in his hand, pointing at the property lines like she was trying to will them to move. By then it was too late. I'd already filed a cease and desist letter, an injunction notice, and a quiet title action with the district court. My legal filings were impeccable, timed to trigger after all final construction approvals were submitted, when she was most financially committed and least capable of retreat. The HOA board had already allocated the maintenance budget for the complex, and she personally signed liability coverage on behalf of the board without reading the fine print, liability which, if she no longer held legal claim to the land, would revert back to her as an individual, not the HOA. I also obtained copies of every lease agreement she'd signed with tenants, public record, thanks to rental registration laws, and began contacting tenants through my lawyer with a standardized polite letter. "Due to a pending property ownership dispute, please direct rental payments to escrow until rightful land title is resolved by court order." That alone was enough to trigger a panic wave. Tenants started calling. Property managers went silent. HOA members started asking questions. Karen tried to stomp the fire out with emergency newsletters about malicious litigation and disgruntled residents, but no one bought it anymore. Not after I dropped a copy of my notarized deed into every mailbox with a highlighted note. Did Karen ever ask permission to build here? Then I filed a formal lawsuit, Maddox versus my name, petition for ejectment and damages, accompanied by a countersuit from my end, my name versus Maddox for unlawful occupation, trespass, willful encroachment, unjust enrichment, and unauthorized development on protected private property. The lawsuit hit her like a truck. She responded with bravado first, called it nuisance litigation, and mocked it at the next HOA meeting. But within 2 weeks, her attorney realized what she'd walked into. He called my lawyer privately to discuss a settlement. We declined, politely. We're not interested in monetary damages, my lawyer said. We want ownership of everything. That's when she panicked. She started trying to undo the damage, begging city officials to pull permits, forge retroactive lease agreements, even floated the idea of purchasing the land at a fair rate. But the problem was she didn't have the money anymore. Every dollar was sunk into materials, labor, marketing, and HOA-aligned capital projects. And her personal assets, already leveraged into loans she signed under the assumption she had uncontested rights to the land. Her investors started pulling out. The construction company filed a lien for unpaid work. And all I had to do was sit there, hands folded, records organized, watching her empire dissolve one misstep at a time. By the time we reached pretrial hearings, her legal team was fractured, her board support had evaporated, and she was desperately trying to claim that I had misled her by not posting larger no trespassing signs. The judge, bless him, actually laughed. Ms. Maddox, do you usually request express written permission before building a 100-unit apartment complex on land you don't own? She tried to pivot to a sob story about community benefit. I submitted photos of her marketing brochures where she called herself the visionary behind Evergreen Commons. The trap had been tied from the beginning, but now it was ironclad. We were just days from trial. She offered one last olive branch, an email, likely drafted through gritted teeth. We propose a 50-50 co-ownership arrangement to avoid further litigation. I replied with a single sentence, you can't co-own something you never owned in the first place. And that was it. The final nail. Karen, so used to issuing warnings, fines, and threats, had finally met someone who didn't flinch, who waited patiently, spoke softly, and wielded a 3,000-page evidence binder like a sword forged from every HOA meeting she ever ruled like a tyrant. She'd built her dream empire on stolen land, and I was about to make it legally mine. The morning of the trial, I walked into the courthouse not as a petitioner, not even just as a landowner defending his rights, but as the architect of a takedown so precise, so thorough, it belonged in a legal textbook's chapter on poetic justice, and from the look on Karen's face when she saw me seated across the aisle in that polished courtroom, I knew she finally understood she wasn't just being sued. She was being dismantled. She came in dressed in a navy blue pantsuit 2 sizes too tight, her lips pressed into a line of artificial composure, flanked by a third-string attorney who looked like he'd just Googled property law defense strategy in the hallway 5 minutes before opening arguments. Across from them, I had a 5-inch binder of chronological evidence, 3 expert witnesses on call, 2 surveyors, 1 forensic accountant, and the quiet, cold confidence that comes from knowing the law better than the person pretending to bend it. Karen's supporters were gone. No HOA members in the gallery. No community show of strength. Just a few nosy locals hoping to watch the downfall of the woman who once fined them for leaving Christmas lights up until January 3rd. The judge opened proceedings with a dry statement of facts. But I didn't need theater. I needed truth, and the truth was simple. Karen had built a 100-unit complex on land that wasn't hers. No lease, no purchase, no right of entry. She had financed, marketed, and claimed full ownership of a development constructed entirely on my soil. Her attorney's opening statement was almost comical in its desperation. There was a good faith belief that the land was HOA controlled due to an adjacent zoning overlay and lack of signage. I leaned over to my lawyer and whispered, they're going with the oops, I build a village on someone else's lawn defense. We both chuckled. But I wasn't laughing long. I had waited over a year for this moment. Let her build with impunity. Let her mock me at board meetings. Let her believe I was powerless. Also, I could close the trap with maximum finality, and now it was time to drop every single hammer the law provided. I testified first. Calm, clear, methodical. I laid out the ownership chain, presented the recorded deed, walked the court through the surveyor's findings, laser-measured boundary lines placing every building well within my property, and read aloud from Karen's own promotional brochures describing the location as securely nestled within private HOA expansion land. I could hear pens scribbling across the courtroom as the reporters picked that line up like candy. Then came the witnesses, surveyors who testified that Karen never consulted or contracted them for zoning checks, the city official who confirmed she never applied for annexation approval, and the forensic accountant who detailed every penny Karen had funneled into the project, showing not only misused HOA funds but personal investment that now had no legal anchor. When the judge asked Karen's lawyer for a rebuttal, he stammered something about constructive use rights and community necessity, but the judge cut him off. Counselor, the issue is not whether the community needed these apartments. The issue is whether your client had any legal right to place a foundation on land she didn't own. The silence was devastating. Karen was called to testify, and against her attorney's visible protest, she insisted. The courtroom shifted. She stood, smoothed her blazer, and walked to the witness stand like she was about to give a TED Talk on visionary urban planning. Her voice shook, not from fear, but from rage held barely in check. "I did what no one else would," she said. "I saw an opportunity to grow our community, to add value. That land was unused, unmanaged. It was obvious he wasn't doing anything with it." I smiled. There it was, the exact quote I'd hoped for. The moment where intent met entitlement. "So you took it," my lawyer said. "You assumed it was yours to develop." "It should have been," she snapped before catching herself. "I mean, it was all part of a community vision. I had the board support." My lawyer pounced. "Support from people who didn't own the land. That's like getting your neighbors to co-sign a car loan for a car you stole." The judge's brow arched. The gallery tittered, and Karen sat back down, realizing her mouth had sealed her fate. The closing arguments were swift. My lawyer reiterated that we were not suing for damages, only rightful ownership and control of the structures built upon my land. We had already filed a quiet title action to claim the development under encroachment and enrichment statutes. All we needed was the court to validate what was already fact. The judge recessed for an hour to deliberate, and I walked the courthouse halls with the same deliberate patience I'd carried through every phase of this campaign, never once rushing, never once doubting. And when court reconvened, the judge didn't waste time. In the matter of land ownership, the court finds in favor of the plaintiff. The development known as Evergreen Commons was unlawfully constructed upon private land. As such, ownership of all structures built upon said land is hereby transferred to the legal landowner. My name, effective immediately. There was a collective gasp. Karen's lawyer slumped. She opened her mouth to argue, but the judge wasn't finished. Furthermore, given the misappropriation of HOA funds and the gross misrepresentation of development authority, I'm referring this case to the district attorney's office for further review. The defendant's actions may constitute fraud, abuse of fiduciary duty, and conspiracy to mislead public officials. Karen's jaw dropped. She turned red, then white, then nothing at all. Her whole body slouched as the reality of it hit her. Not only had she lost the project, she had built me a multi-million-dollar complex from scratch. With her money, her time, her contractors, and I owned every square inch of it. I exited the courthouse with the deed in hand and a copy of the court ruling under my arm. Reporters swarmed. I said nothing. I didn't need to. The headlines wrote themselves: HOA Queen loses empire in landmark land grab ruling, and judge outplays road developer, wins 100-unit complex. Karen? She was removed from the HOA within 48 hours. Her assets were frozen, pending investigation. Her reputation collapsed like the very tower she'd tried to build over my name. And as for me, I hired a new property manager, filed all the rental licenses properly, and renamed the complex Second Chance Village. It felt appropriate. The tenants stayed. The checks came in. The land, my land, flourished. Because the woman who thought she could steal, it had forgotten one simple rule. You don't build your kingdom on another man's land, unless you want him to own everything.